Hi guys, welcome back to my channel. So today in this video I would like to continue my previous video entitled The Shipping Law Review, United Kingdom, England and Wales. So this is the second part of the video. 2. Arbitration and Adr. Maritime disputes are often resolved via London arbitration, and the vast majority of international shipping arbitration are currently dealt with in London. For a dispute to be subject to arbitration, there must be an arbitration agreement which may be either written in the contract under which the dispute arises or agreed between the parties after the dispute has arisen. The London Maritime Arbitrators Associations LMAA is an association of specialist maritime arbitrators operating in London. In 2021, the LMAA received approximately 2,777 new arbitration appointments and published 531 arbitration awards. LMAA arbitration is frequently used to determine commercial shipping disputes, such as a third-party and bill of lading dispute, ship sale and purchase disputes, shipbuilding and repair dispute, marine insurance dispute, and offshore and oil and gas disputes. LMAA arbitration is not usually used for collision and salvage matters, salvage being more commercially resolved by yacht salvage arbitration. The LMAA operates within the framework laid out in the Arbitration Act 1996 and published in its own set of rules, which are structured to deal with small, intermediate, and larger cases. The most recent rules were published in 2021 and apply to all LMAA rules were published in 2021. And apply to all LMAA arbitrations commence on or after 1 May 2021. Several forms of alternative dispute resolution are used within England and Wales, including export determination, early natural evaluation, early inventions, and mediation. Mediation in particular is an increasingly popular option for settling maritime disputes. Both the Admiralty and commercial courts and the LMAA encourage parties to dispute to engage in mediations before proceeding to trial or arbitration. If a party refuses to mediate without reasonable ground for doing so, the court may be an adverse cause order against the refusing party. Additionally, if an English law contract contains a mediation clause, this clause will be enforceable by the parties to the contract provided that the clause is sufficiently certain. 3. Enforcement of foreign judgment and arbitral award. Foreign judgment. Following the end of the Brexit transitions period 31 December 2020, England and Wales are no longer able to rely on the various EU conventions on jurisdiction, service, and enforcement. The Brussels I regulation, which covers the recognition and enforceability of judgment between EU member states, no longer applies to claims unless issued or before 31 December 2020. The Conventions on Jurisdictions and the Recognition and Enforcement and Judgment in Civil and Commercial Matters 2007, or the Lugano Convention, which regulates the enforcement of judgment between EU member states and the European Free Trade Association countries, also no longer applies to claim unless issued or before 31 December 2020. The United Kingdom sought to join the Lugano Convention in its own right, but required the consent of the EU member state. On 8 March 2021, Switzerland approved the United Kingdom's application to accede to the Lugano Convention. However, in June 2021, in a note verbal to the Swiss Federal Council, The EU Commission said it was not impossible to give its consent to invite the United Kingdom to accede to the Lugano Convention. The Swiss Federal Council acted as the official depository of the 2007 agreement. The Hague Conventions of 30 June 2005 on choice of court agreement, which continues to apply in England and Wales to certain contracts, requires the Court of Contracting States to uphold exclusive jurisdiction clauses and to recognize and enforce judgment given by court in other contracting states that are designated by such clauses. The Administration of Justice Act 1920 and the Foreign Judgment Reciprocal Enforcement Act 1933 govern the recognition and enforcement of judgment made in the Commonwealth and other reciprocating countries. This act requires judgment to be registered before they can be enforced in England. The requirements for registration are that the court that issued the judgment must have had jurisdictions and the judgment must not have been obtained by fraud to be contrary to public policy. Once registration was occurred, the judgment will take effect as it were an English judgment. Enforcement of judgment from countries that are not party to be above statutory regimes is governed by English common law and require the commencement of a new action based on the judgment itself. The English court will not examine the merits of the judgment. However, it will be necessary to show that the court that made the judgment had jurisdiction to do so under the English conflict of laws rules, that the judgment is for debt a limited sum and it is final, conclusive and not contrary to public policy. Foreign arbitral award. Many foreign arbitrations awards are enforceable within England and Wales, and these positions remains largely unaffected by Brexit. The United Kingdom is a party to the Conventions on the Recognition and a party to the Conventions Enforcement of Foreign Arbitral Award 1958, the New York Conventions. Accordingly, most awards from other contracting states are enforceable. Enforcement is governed by Section 66 of the Arbitration Act 1996. It is also possible to enforce an award issued by a non-contracting state. Again, enforcement is covered by Section 66 of the Arbitration Act 1996 and by common law. The key criteria for enforcement are that the award is valid under its own governing law and that it is final. Shipping contract, shipbuilding. English law continues to be governing law of choice for parties entering into shipbuilding contract, and so England and Wales remains a key jurisdictions in this respect. See the shipbuilding chapter for further discussion on the law of this area. The United Kingdom itself has a proud history of shipbuilding spanning many centuries. However, since the closure of many yards in the 1970s and 1980s, commercial shipbuilding has been in significant decline. Second, contract of carriage. The Hague Fisby rules incorporated into English law by the Carriage of Goods by Sea Act 1971 are the silent convention rules applicable in this jurisdiction. The rules will apply compulsory to bills of lading when the port of shipment is in England and Wales or when the bills are issued there. Further legislation on the functions of bills of lading and contract of carriage has been enacted by the Carriage of Goods by Sea Act 1992. There is no specific legislation governing multimodal contract of carriage, although it is generally accepted that the Hague Fisby rules will apply to the seagoing leg of such contract for carriage. So the time is up and the article will be continued to read on the next video. So bye bye, and don't forget to like, comment, and subscribe. Bye.